Hello, hello, hello. This is Attorney Mike Graham coming to you from Chicago as usual. Oh, I threw one together here with a lot of help. I need to thank Amy Sater, who tipped me off to one in Boyd this morning. I ultimately ended up poaching it from Lone Wolf, who is awesome. Big shout out to Lone Wolf. Link to his video and his channel in the description below. I also just recently, you see from the thumbnail, got one from Elkhart Court. Elkhart Court is also awesome. Although it says in my, this can't be, whatever. It says that in my Discord, it says that CNN put it there. I don't know if I'm reading that wrong, if I'm just being a boomer about this or what, but there is no way on God's green earth CNN sent me anything. I guarantee that, but that's what it says in my Discord. Of course, in the world of the internet, I've got Chili DeCastro sending me things as delete laws, and I don't think it's delete laws. And I've got Jay Regere's love child sending me things. I've got Kinky Kelly sending me things. And now I've got bacterial vaginosis sending me things. Because part of the deal here at Law Talk with Mike, in case you don't know, is my people can't behave. And I'm too busy to notice. That's how it is. Also, Zach, Law Nerds Unite, hooks me up. We get the follow-up. I haven't even seen it, but we had this goof earlier. I put a link to that in the description below too. We had a fun video this morning called Don't Get Hoity Toity with Me. Judge Dad goes full Judge Dad. And he kicks her out in the hall to talk to her attorney because he's just disgusted. She comes back. I haven't seen it. I don't know if it's fun or not. We'll find out. But I know that we got some I know we've got some dopey pothead rolling in to court on a small claims in California. That's from Elkhart Court. I saw about a minute of it. It looked fantastic. I didn't have time to look at the rest. I'm sure it's good. Let's get it started, shall we?
You raise your right hands to be sworn.
You each solemnly state that the testimony you shall give in this matter be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Was that Rena or Tiffany?
Tiffany.
Rena,
I do.
Okay, thank you. Everybody can sit down. I'm not sure exactly what the case is about, but it may be employment. I can't age discrimination, but some type of discrimination.
That's a good question. I don't know what court this is in. This is all Elkhart Court's doing. Credit to them.
The way that we're going to proceed is that I'm going to hear first from Mr. Moat, then I'll hear from each of the defendants, and then Mr. Moat will get to reply to what they say. We go in that order because the person suing has the burden to win the case. The burden in this court is by ponderance of the evidence. And so that's the burden that Mr. Moat has. So he gets the first and last word in the case. And I have exhibits from the defendants in our exhibit app up. And
I think I just, because I don't know the flow and I haven't seen it. I think I just need to get this out of the way.
If you didn't know, y'all stink. Okay, that's just my opinion.
okay, Mr. Moat, do you want to tell me more about your claim?
Yes.
Hold the microphone closer.
Oh, see, it's loud when it's close. Okay. Better? Good. I went to the establishment. I was talking to
Establishment.
their store. I went to
What store? You give me.
I'm sorry. I went to the dispensary. I went to the dispensary called in Pacific Beach to get medication.
Which company owns the dispensary? Was it Mission Bay LLC or the cannabis company holding Inc.?
It's called Cannabis.
Yeah, but that's just a name they do business under. Which company owned the store?
Oh, I'm not really too aware of that. That's where the court.
Yeah, I know this is the first part. That was the moment where I'm like, I just have to do it. Like, he doesn't understand the concept of a DBA. The judge, I don't know if he understands the concept of a high on. We are going to have a communication breakdown instantaneously. Let's do it.
I had to look up who to serve.
Right, but you have to prove it.
Prove.
I can't put a judgment against somebody who doesn't own the business.
I went to the cannabis company and the people that, I'm sorry, I'm confused.
But
Yeah, you're a high on. See, it's you know, I do this all day. I actually do this, and I file civil actions, and it's really important to name the defendant correctly. Like, if you don't do that, nothing else works.
it would be like somebody suing you, but not knowing whether it should be you or somebody else.
I went to the company that these people were served for to
People, you sued two companies. Which one is it, the LLC or the Inc.?
I'm not trying to be difficult, Your Honor. I initially sued.
You say you don't know.
I initially sued the business. Oh, I can say I don't know.
Yeah, you can't sue a name. You have to sue a company.
Well, I initially went to the business where I had my issue, and they told me that's
The judge. So you don't know. Okay.
I can't serve them. It's owned by lawyers, and I had the court look up who to serve.
But you've served two companies, just so you're clear, or you've named two companies. So I'll hear from them and they'll tell me which one of them was that I.
Okay, I did what the court told. I served who the court told me I had to serve to sue this business.
That still doesn't make it.
Okay, I'm sorry.
Right. So anyhow, you go to the dispensary called Cannabis. Go ahead.
I went to get medication. I was speaking to an employee. Another employee came out of nowhere.
I think this judge is the only person in the state of California who's never been high. He is just not understanding what he's up against. He is running under the presumption that this guy is competent at anything. It's too good.
Yelled at me I was too old. I apologized for being too old. She again yelled at me I was too old and held my driver's license up in the air and screamed my age out to the business. And then I think she might have reached and tried to slap me. I can't recall. And then I tried to call and get an apology from the managers at that store, the managers at another store. I told them I was going to sue them. And then I got a call from Mr. Schulte in Denver, which is a one-party record state. So they probably did record the call, but I can't prove that. We could just presume that they did.
Was this a manager that yelled at you and tried to slap you, or was it?
No, it was some employee.
I'm talking.
Oh, I'm sorry.
Or was it just an employee?
I do not know. It was someone working there. They could have been a manager or employee. I'm not sure what their title was.
And then what happened after they yelled at you or she yelled at you?
I don't know. I've not seen this, but I will say this right now. These two ladies have the right attitude. Just that look of like, what the hell are you doing? Is the perfect response to this mope.
You. It was a female, right?
Yes, and I apologized for being too old for whatever I did. She didn't accept that apology, and she got louder, yelled my exact age out with my driver's license in her hand to the entire store, and then kept yelling, "You're too old," as I left the store.
How do you get $12,000? Oh, I'm sorry, wrong number. $12,500.
Yes, Mr. Schulte asked me that question when he called and told me he was going to countersue me, and since I didn't have any money and I was indigent. Oh,
how did you get the number?
I just I looked for the average case of, because I looked up my rights as a consumer. It kind of fits in with employee. I know it's not all there.
What?
I just took the average case.
Ask you a different question.
I took the average of.
Just happens to be the maximum you can get in this court.
I took the average of.
I took the average case. It has nothing to do with, actual damages that I can prove. I just took the average of this case, and that's probably the maximum for the court, and probably everybody asked for it just because it's the maximum, which is like not bad, but at least if you just admitted that, the judge would be like, okay, it's dumb, but fine. This guy's trying something else. Oh, good Lord.
If I was an employee, if we were both, I took the average of if we were both employees of what my average lawsuit would be in California, and it was like 60,000. So I just was going to I was going to put that, but I couldn't. So I put the max here.
If you were an employee, but you weren't an employee.
That's correct. But as a customer, I get some rights as just to walk into your store and not be attacked based on age, race, and religion.
It's almost as if the drugs have affected your ability to think.
I didn't, and I came to the amount.
What law are you relying on?
The law. I Googled what's my protected rights are. Age, race, and religion are protected.
As a customer of a private store?
Yeah,
Every circumstance is different, depends on the setting.
it's a store where I had a medical license to go get medication from.
You have a medical license?
I did have it for marijuana, but now it's just a waste of money because you don't need a license for it anymore. But when it
When
first
did
came
this
out,
happen?
I'm sorry,
What was the date of the
I
incident
believe it was November 1st.
of 2024?
Yes, sir.
That's what your paperwork says. And so did you have to go to another dispensary to get your marijuana?
No, but I wanted to see. I was expecting to not have to say anything because all this
Did you fill the marijuana prescription?
they did as they yelled at my age and told me I was too old to be in there. Yes, they handed.
gave you.
After I paid for it, they did. As they yelled at me, they yelled at my personal information, attacked me based on me being old.
Okay. Let me hear from.
Real quick, Your Honor, I didn't expect to say anything because when I first said I was going to sue them, Mr. Schulte
Yeah, I'm with you. The baseline has to be low. The weed doesn't help, but the baseline has to be low.
called me and threatened me with countersuing. So I'd assume they showed up. This is all on video. There's a million video cameras of this incident of occurring between me and them.
Them to the court?
They have the videos. I can't submit them because they won't give them.
You subpoena them to the court.
I didn't know I had to subpoena them. And I'm
That's how you
also-
would've- That's how you would have gotten them here.
well, the lawyer threatened to sue me. So I figured he
This judge is so straight-laced. He's right about everything. The judge is spot on about all this stuff, but he's just Dudley Do-Right over there asking him questions like he's talking to me. He's talking to this guy like he knows something. I can't get over it. It's too fun.
would bring his evidence to countersue me.
They don't have to say a word. They can be totally silent. So anything else you want to tell me before I hear from them?
No,
Okay.
well, yes, one thing.
Let me hear
Thank you,
from them.
Biggin.
So, Miss
Welcome all.
Street or Straight, I'll let you go first. You're with the Cannabis Company Holding Incorporated. Go ahead, ma'am.
Yes. So that store was holding a Halloween themed event. They had different costumes through the first, and one of our retail associates.
And I
was wearing
object.
a-
That has nothing to do with the
Sir,
case.
No
Okay.
objections,
Sorry.
please. It's her turn. So there's a Halloween theme event.
Yes, one of our retail associates who was checking IDs was wearing a costume that involved horns, and Mr. Moat made an offensive comment about whether or not she was horny, and Miss Regina then stepped in as the manager on duty as the senior retail associate to let him know that that was not appropriate and we would not tolerate comments like that. Mr. Mote then tried to justify and defend himself throughout throughout the store while he was making his purchase, in which at that point in time, once his purchase was
I wasn't aware of this. He just thought he just thought he could. I mean, this guy's dumb, but his social calibration thought, "Hey, I can just drop a "Are you horny?" on this on the at the dispensary with people that don't like you."
completed, he was asked to leave, and we, as a private entity, made the decision to not allow Mr. Mote to shop there in the future to protect the respectful work environment for our employees.
Was it the manager who stepped in? Is that what you said?
She was a senior retail associate, which at the time would have been the acting manager on duty.
She was not.
And that was not the person who was wearing the Halloween costume, though.
No,
that
she
was
stepped in on behalf of that person to ensure that our expectations were met, which is well
So
within her rights.
why-
Of her.
Okay. So which one was horny?
Why would his license have to be looked at?
So licenses they're provided and checked in to ensure that they are valid and that they are of age of over 21 to be allowed into the establishment per the cannabis regulations for the state.
And what about his allegation that his age was published by reading it off of the driver's license?
That would be answered by Ms.
I
Rena.
could answer that question. To answer the question,
Well,
his
wait a
ID.
minute, wait a minute, slow down. Before you do that, who owns this store?
So
it
it
the
is owned by the cannabis.
LLC or the corporation?
So the Mission Bay LLC is the licensee holder, which is owned by the cannabis company. Yeah, Holdings Inc.
So the
I think
LLC, it owns the business. Is that right?
Yes,
And the cannabis company, is that the parent company?
yes.
And okay, so Miss Seong, you were going to say something about the license, the driver's license.
So just to get a real quick baseline, customers come through the front window, they drop their ID, they get checked in by the receptionist. My receptionist that day was a newer sales associate. She just got hired about 2 weeks ago. She lets the customer in. I see him. He starts asking me questions about product. We helped him figure out what was what and what deals he was going to get. As we're finishing checking him out, he then made the comment about her being super horny. And it was just very inappropriate, obviously.
Yeah, it's creepy as hell. We get it.
Let me
So
stop
I
you
just-
again. Were you were the senior retail associate at the time?
Yes, sir.
Okay, I didn't get that in the beginning. All right, I'm sorry. So now
I mean, it's completely out of line. She may have only been moderately horny, and that's for him to make that step, to make that logical leap, it's out of bounds.
step in. Go ahead.
Yes, sir. I stepped in and I asked him, I said that was inappropriate. I'm going to ask you to refrain from speaking to staff like that. Because if I had not been there, who knows who he would have been talking to like that. So I stepped in and asked him to refrain. Instead of apologizing or just stopping where it was, he doubled down and continued to I was just talking to her. I wasn't talking to you. She's not even saying anything. And I said, yes, you just made both of us feel very unsafe in our place of work.
Okay.
He did not
Anything
like
else?
this answer and
What about yelling something about his age or reading his age
I did
off
not
of
do
his
that,
driver's license?
I
Pardon
would
me?
never do that.
Oh my God.
I would never do that.
Just the insane ramblings of a high moron, Judge, and I believe her.
Okay.
You could ask anybody who worked that day. It would
I categorically do not believe all women, but I'll believe this one.
be the same answer. That did not happen.
Anything else either of you want to tell me?
No, Your Honor.
No, Your Honor.
Okay, I'll hear lastly from Mr. Moat. You get to reply to what they said. Anything new or different? Don't repeat anything you've already told me. Anything new or different you want to tell me?
They lied.
Not just this one. I believe all of them that say things that seem believable.
And I was hoping the judge could request that video to show that they lied, since they swore that they would not. And the judge can watch the video and determine that they lied in their case.
Yeah, I can't.
No, you can't.
You have to produce it yourself.
Yeah, I thought they would put.
Anything else you want to tell me?
So I'm really mad because they didn't bring my made up evidence that I have against them and provide it to me to help my case. Yeah, too bad.
I was attacked, and I didn't do anything to be attacked. I didn't attack anyone in the wrong way.
Yes, the girl if she was super horny. You know.
Anything new or different?
No, sorry, Your Honor.
Nope.
I just
All right, let me make my decision. The burden of proof, as I said, is on Mr. Moat to prove by preponderance of the evidence that his claim has merit. At best, the evidence is equal in this matter, which means he doesn't meet his burden of proof.
No, he doesn't.
So judgment will be for the defendants. Thank you, folks. You can disconnect from the virtual appearance. Sir, you're welcome to leave. Thank you.
Thank you, Your Honor.
Let's go to our
Police.
Okay, big shout out to Elkhart Court. That was fun. I wasn't even aware of that call. That was one of the most fun appearances I've seen recently. It really was. Okay, this morning I did this. Judge McNally goes full judge dad. He said he tells this woman to not get hoity-toity with him. He says, "Don't talk to me. No, don't talk to me like that." The whole thing was good, and then he kicks her out in the hall. I couldn't follow it because I had actual court appearances today. But thankfully Zach over at Law Nerds Unite got it, and I have not seen 1 second of it.
Noel Jackson, 25E48486. A and B, 25E148570, A and B, 19T633606A. Your appearance?
Yeah, you only have Talise Jackson, state your name for the court. Talise Jackson.
I hope you adjusted your attitude. You adjusted your attitude since you were back up here before?
I've adjusted my emotion.
Okay.
She's had some things happen.
All right, let's go through one file at a time. All right, let me start on the notes. 25E148570, A and B. We've got a defense date of April 18th. They're going to dismiss those if she pleads on 25E48486, A and B. That trial I'll suspend and the disobey stop sign. And then we have to deal with the warrant on the 19 case. So is that, first of all, for purposes of arraignment on all of these, does she stand mute, wait, formal reading?
Yes, Your Honor.
So I'm entering not guilty pleas for her on those. Now, if the other two are from the incident date of April 18 of 25. If you plead the disobey stop sign, that is a 3-point civil infraction. If you plead, excuse me, to driving on a suspended, the possible penalties are up to 500 fines, 93 days jail, costs for all those. Do you understand that?
Yes, I understand.
And there's 2 points that would be added to your traffic record. Do you understand that?
Yes.
All right, did you sign? Well, actually, on suspend there be 2. On the disobey stop sign, there's 3. You only get the higher 2-point total, so you get 3, not 5. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right, to the charge driving on a suspended, how do you plead? How do you plead, ma'am?
Plead guilty.
On April 18 to 25 at 2:14 p.m., were you operating a motor vehicle on Mills Drive near Valley in Brownstown?
Yes.
Was your license suspended?
Yes.
To the charge of disobey stop sign, responsible or not responsible?
I will stop.
Right now, you are on probation still to me on this other, wait a minute, let me just double check. Well, I didn't. Yes. Only did was place on probation. You're on probation to me on this 19 case, right?
Yes.
You understand by pleading guilty to this suspend, that would be deemed a violation of this probation. This probation could be revoked. You could be incarcerated on this charge. I'm talking about in the 19 case as a result of the plea and conviction from the 25 case. You understand that? And you still wish to plead guilty? I can't hear you, man.
Yes.
I can't, I'm sorry.
Yes. Sorry.
Anybody force you to plead guilty?
No.
Please accept it to that charge of driving on a suspended. Please accept it to disobey a traffic signal. Now we've got this 2019 case. All I did was put her on probation on this only because I wanted to clear her. She must have had a ton of warrants. And I said all suspensions to be lifted by March 1 of 20. How ironic. Just so you know, even though she got real testy with me. as though I'm incorrect by questioning why she hasn't been here since 2019. She goes out on these cases. I don't have an answer for this because I haven't looked at her record, but my strong belief is she probably never has had a valid license, even though I told her to have the valid license by March 1 of 20. And then, not only didn't she have a valid license on this date, she also picked up one 4 hours earlier, and she's in here acting like she's oppressed. Go ahead, what are we doing on this one? Is she pleading guilty, or does she want a hearing on failure to attend her scheduled probation visit? It looks like on, I can't tell, it's a typo, it says 68/9/19, so I don't know if it's June 8th or August 9th, 19th, so that's.
I think it was May 30th, 2019.
That's what I sent.
That's what she was saying.
But I'm talking about, there's a 3-count warrant here, show cause that she didn't show up on, failure to attend her scheduled probation visit, failure to pay fines and costs as directed, and failure to clear all warrants as directed. So how's she going to proceed on that?
So, Your Honor, did you want the explanation? Okay, so.
She either needs to have a hearing or she needs to plead guilty to those counts.
Will be guilty with an explanation.
Okay, let's call in somebody from probation. I don't know what day. All right, if you plead guilty here, I want you to understand you could be incarcerated for up to 93 days. Your probation revoked. Do you understand that?
Yes.
And you understand all your rights?
Yes.
And you understand you have the right to a hearing?
Yes.
And you understand if you plead guilty, you're giving up your right to a contested hearing, you're giving up your right to remain silent at that hearing, you're giving up your right to cross-examine any probation witnesses at that hearing. If you plead guilty, you're giving up all those rights. We won't have a hearing, and you could, again, have your probation revoked. Do you understand that?
Yes.
All right, so the charge of failed to attend your scheduled probation visit, which I'm just going to say it was the first visit, it appears. After sentencing, how do you plead?
Guilty.
Did you fail to appear at that probation visit?
Yes.
Got to keep your voice up. It's the count 2. Did you fail to pay your fines and costs as ordered? How do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes, I guilty.
Is the count 3 that you failed to clear all warrants as directed? How do you plead?
Guilty.
Did you fail to clear all your warrants as directed?
No.
You cleared your warrants?
Oh, I'm sorry. Yes.
I'm going to ask you again, the charge you failed to clear all warrants specifically by June 4 of 19. How do you plead?
Guilty.
Did you fail to do that?
Yes.
Anybody force you to plead guilty?
No.
I'll accept the plead all 3 counts. Ms. Wiles, I'm going to ask you in a moment to tell me what day the probation visit was supposed to be. There's a typo in this show cause that was generated back on August 15 of 19. All right, Ms. Patillo, what do you have to say? Give me something good here, because not only did she blow this off, not only did she drive twice on a suspended license within 4 hours, she came in here like brimming with, like, who do you think you are questioning me? And that just tells me she doesn't see anything wrong with what she did. And that spells bad news for her. So first of all, you tell me, and you can gather your thoughts as to what day that was.
Yes, Your Honor. Elizabeth Wiles, Probation Department. It was August 9, 2019.
The wheels of justice are going to roll you right into the Wayne County Jail.
Yes.
I don't know if I need you even in here, to be honest. I just wanted to clarify that.
Yes,
The
Your Honor.
failure to report was on August 9th of 19, right?
That is correct, Your Honor.
Okay.
All right.
All
Thank
right,
you.
so thank you very much. You're all set. So Ms. Patillo, what would you like to say? And by the way, just for the record, I am dismissing pursuant to the agreement the 2 other cases that the prosecutor agreed to dismiss, 25B1485708A and B. All right, so what would you like to say?
So, Your Honor, Ms. Jackson does apologize for how she entered the court. Back in 2019, Ms. Jackson indicated to me that she had some very bad family issues. She was in an abusive relationship, and I believe the abuser's case was in this court. She had to come and
Oh, spare me. every freaking time it's some guy's fault. She's in an abusive relationship. If she is, it's her own fault. I mean, I don't know any of the facts, but come on. You're driving without a license. It doesn't have anything to do with anybody else.
Testify, not against him, but for him. It was very upsetting. She has 3 minor children. She is currently.
I would double whatever I was thinking for the absolute audacity of that stupid argument.
Employed at Ford, but back then what happened, it was a mix of the pandemic hit right around March 20th. She did fail to attend that first hearing.
Well, but wait a minute, but this was, the pandemic didn't hit till 20.
Right, but on March 1st, 2020, she was also supposed to, she failed to attend the meeting on that date, it looks like. That's what I have on my notes. The reason that she failed to attend the hearings, one is that, and you can tell me if I misspeak, did you think it was non-reporting probation?
Because she's an entitled a-hole. That's why, and we all know it. Stop talking.
That's what I do to understand, is that it was non-reporting probation.
I might have given you non-reporting probation, but they still got to explain that order initially, so.
I was pregnant at the time.
Why?
She had a lot.
Okay. The good news for her is I'm not one of these to hold anything against her, even though she acted juvenile. We're going to work through this as long as she understands she made a mistake and acknowledges.
I am. If I was on the bench, they'd call me Mike, the carries a grudge hanging judge. You pull that crap in my courtroom, there's going to be a tax on that sentence.
It goes so much further with me than somebody comes in and acts like we're inconveniencing them. She needs to figure out what she's going to do. She didn't clear her warrant. She didn't pay the fines. How's she going to pay the fines?
She could have a payment plan for the fines.
Where does she work now?
Ford.
She's making $32 an hour.
Okay, so
I mean, I think that's great. Do you have, how many kids do you have?
I have 3 sons,
How old are they?
14, 5, and 8 months.
Are you collecting any child support?
No, he's dead.
Oh, geez, I'm sorry. I really am.
Wow.
Okay, I'll tell you what I'm gonna do. All right. Let me see something here. Counsel, I'm gonna set this for sentencing. I'm gonna set all these for sentencing. If she's gonna get her act together and she's gonna get her money together, she's gonna try and go and clear warrants. That's what she's gonna try to do. I don't remember where they all are. We're gonna give her a sentence date. I'm just gonna make a note, defendant to save money. Clear warrants.
Judge to verify story, which may or may not be true. If it is, I have sympathy. I do. But I don't really trust anything that's coming out of her mouth based on what they've done so far.
We're gonna give her about 5-6 weeks to come back. So hopefully she'll at least be able to pay this one. And then I will set a sentence date on the other 2.
Okay.
So how long do you think it'll take you to save about $400 on this suspend charge, ma'am? Oh, wait, she's got a bond. She posted a bond? Oh, that's in your name. You got 4,010%. Okay, so we keep by law, how much is that? $455. Now I'm gonna continue the bond. You save money on these others. You go over and try and clear your warrants. Let me just check. Did you see where she's got warrants outstanding now?
Judge, some of them you cleared, right? Your license is.
All right, here's what I'll do. We'll just continue your bond. We'll give you a sentence date. Lisa, give me one in about 5-6 weeks when Ms. Patillo is here. Will you please?
June 18th at 8:30.
June 18th at 8:30, okay?
Okay.
So that'll give you time to save some money and do whatever else.
Oh,
Stop
God.
driving.
He is a simp at the end of the day. He really is.
Please don't let me see.
My license is valid.
Oh, it is? Good.
I just want to apologize.
You're fine. Let me tell you something. I believe you. I believe you.
I don't.
I believe you. It's all right. I am not going to hold those kinds of things against somebody. I'm a horrible judge if I do that. You're gonna be fine. We're gonna help you. Just show some humility and go so far.
Yeah, but I'm not trying to act like a victim. I was
All right, you're fine. Let it go. It's okay. You're fine, honestly. Good luck. I really wish you well. Go down the hall, get your notice, and we'll see you back here, okay?
Thank you, Judge.
Thank you very much.
Karen Lampkin, if you'll come forward, please. Yes, if you'll come forward.
All right, and this is Lone Wolf's video, and he's just very cool. Big shout out to Lone Wolf. Link to this in the description below without me talking over it. I saw a little bit of this, and again, I had hearings I had to get into because I was warned about it early, and I started doing it, but then I had to stop. Nonetheless, you still had to patch this thing together. This guy's a goof from what I could tell. I was just a short way into it, and he was goofy. I did want to see the rest, but I've only seen a little bit.
You always dress appropriately for court. I appreciate that. No, that's good. All right. So what's going to end up happening? We're currently in a jury trial, so I can't do jury trials at once. I've done that before, but the staff is like, Stephanie, it's too much. Yeah. So what's going to end up happening is your case is going to be recalled for another trial setting. And you have a choice. You can have a jury trial or you can have a bench trial. Jury trial, 12 people will hear the evidence and they'll make a decision on whether you're guilty or not guilty, or you can have a bench trial. Okay. A bench trial is where I hear all the evidence and I make a decision. What I can tell you, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. So that's something for you to think about between now and your next court date. Okay. Okay. All right. Ms. Ferguson, when is criminal trial division up next? We're going to put it on the 20th. Well, actually, what I'm going to do is I'm going to put you on May 19th. Mm-hmm. That way, if you have any motions that need to be heard, we'll hear motions. And then after your motions are heard, then we'll bring you back on the 20th. Okay. On the 20th. Okay. All right. So let me do this first. We're going to go on the record. Court is calling 2024 CR 009936 State versus Carrie Lampkin. Are you Carrie Lampkin? Yes, sir. All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right. You can lower your hand if you'll state your name for the record. Carrie Lampkin. All right. I'm going to ask you some questions, and the questions, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself. Okay. Okay. It's like qualique. This is a qualique. A what? Qualique. To see if I'm able to represent myself. Yes. Okay. All right. So how far did you go in school? I'm currently in school right now.
I like it, David.
Graduating next year, but now that I'm now getting behind with finals because of. All right. So here's the thing. The best thing about being a witness and what attorneys always tell witnesses is just answer the question that's asked of you. Okay. So how far are you in school? I'm in college now. All right. What year? I'm considered a sophomore/junior. All right. And what are you studying? Law. All right. And how many years have you studied the law? I'll say about 5 years.
Oh boy.
All right. But it was in the
You know what they usually call people who studied law for 5 years? Attorneys.
Civil litigation and family law. And so have you ever studied criminal law? I never had a desire to learn about it until now that I'm going through this. All right. So remember what I said. Just answer the question.
Well, now it's time, isn't it?
Have you ever studied criminal law? I've never studied criminal law, but
based on my study, it's like all civil in nature.
All right.
Yeah. Yeah. Uh-huh. Well, you commit a lot of crimes, so there's some familiarity there.
So here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney. Do you understand?
Yes, ma'am.
I don't know. That's the very question that Lone Wolf asks in his description or whatever. Well, we'll see.
All right. So do you want to have one? Can you afford an attorney?
Well, at
That's
the moment,
yes or no.
at the moment, no, because of
All right. Then the
I
next
think-
question. Here's the thing. Just
Yeah,
listen
see, we already knew
to the
that.
questions.
We already
all right?
knew that.
Are you able to afford to hire an attorney?
no.
All right. Would you like an attorney appointed to you? That's either yes or no.
But I'd be able to speak to counsel, like someone from my counsel, to be able to make a decision. I don't want to just rush and say yes and no when I don't.
No, I mean, here's the thing. You don't get a chance to choose who your attorney is.
Yes.
My question for you is, and I just want you to answer my questions.
ma'am.
Would you like to have an attorney appointed to represent you? That's either yes or no.
Your Honor, I'm sorry. I'm like, I just feel like I'm being pressured and rushed, and I don't.
No, you're
wanna
not being
make
rushed.
that
This case has
decision.
been going on since January 2025. Let me explain something to you. When this case,
Don't. I can't think. I can't think of anything appropriate to say. That's disappointing, shall we say? That's embarrassing.
comes to trial, it is going to trial.
Yes, ma'am.
There's not going to be at the last minute, I decided I don't want to do this. Let me get an attorney and get another reset. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any resets because in the middle of trial, you decide you're over your head
Mhm.
and you need an attorney. That's not going to happen.
Your Honor, with all due respect, my attorney, I had.
Here's the thing. Don't start with
Yes, ma'am.
with all due respect. And let me just tell you why.
I'm
No, no, no.
honorable and
This is what I want to tell you. When people say with all due respect,
Mhm.
they're really getting upset. And usually what comes after with all due respect is not with respect. It's with you. Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No
I'm not-
problem.
I was just wanted to say with all respect, Your Honor, the reason why I
But with all due respect, you really were.
withdrew from my attorney, there was an issue with discovery since day one when I
Okay,
hired.
here's the thing.
Mhm.
I don't get into things about you and attorneys and what happened with your previous attorney
Mhm.
unless your previous attorney is here to
Understand.
give their side of things.
Yes. So, like again, Your Honor, so I'm not affording my due process rights. I don't know. It's like to me, it's like you're making a judicial decision, and I don't.
It's not. It's either you want an attorney to represent you and afford one.
I'm asking you nicely, Your Honor, if I could have some time to make that decision because I don't want to make the
And she's telling you nicely, no. Now grow up.
right decision if I'm going to defend myself. I'm already lack of discovery.
My answer to you is no.
Yes.
If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial. And when you come in, it's going to trial. That's where we are. And I'm going to tell you again,
Mhm.
previously, when you were saying you were filing your bill of particulars,
Yeah.
I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion. And if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just going to be denied.
Mhm.
So it's not going to be my job to walk you through questioning of witnesses. I'm assuming if this goes to trial, the state is going to call witnesses.
Okay.
Not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence or criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects and it is an appropriate objection, then it's going to be sustained.
Yeah, I'm
So-
not asking for any legal advice or
You have been though, because the motions that you've been filing have not been appropriate motions. Your bill of particulars, when I read it, it's really not a bill of particulars. What it is a request for a pretrial hearing on certain matters. This is going to be going to trial.
be respectful as possible, Your Honor.
No.
But you're applying pressure on me to make a decision, and everything is moving faster.
Oh my God. I cannot take it's an epidemic. It is an epidemic in our culture, the complete lack of masculinity. And this guy is exhibit A.
Like, I don't consent to go to jury when I got my due process has been violated. I'm praying that you can hear me out, but it seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you received that. And here's the thing, you're saying that's not true.
I have substantiated
But-
evidence, Your Honor.
But listen to me, put on your listening ears.
Yes, ma'am.
This is what I'm telling you. Your attorney, the attorney that you hired,
I didn't hire him.
your attorney.
That's actually a good question. He claims that he's a law student, but that's just self-reporting. So he can just say that, or you can just mean it in the generic sense. Like Chili says, oh, I've been studying law for the past 20 years. I mean, you could read the police blotter in the local paper and claim you're studying law. You're not learning a damn thing. You'd learn more watching Law Talk with Mike by a wide margin, and we go out of our way to avoid it. But all I can say, so I don't know if he's enrolled in some program or not. All I can tell you is, from my perspective, listening to him, he knows nothing.
Attorney,
I didn't hire him.
your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney.
Mhm.
That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you haven't received discovery. Your attorney says you have.
Yeah.
So, no, let me stop you there. So what I am telling you is this is going to trial and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason to disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery.
Mhm.
Their question, and this is the last time I'm going to ask it, and you can answer it. If you don't want to answer it, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer it. Do you want an attorney appointed to you? Yes or no?
The pressure, I don't understand.
All right, that'll be no.
Being
Ms.
respectful.
Ferguson, place this on the jury trial with Judge Angelini on June 16th.
So I'm not able to talk, Your Honor.
Sure, you can talk. Go ahead.
So I have placed on the record, Your Honor, substantiating evidence of the proof that I have not been able to receive discovered. On May the 3rd, May the 3rd, I have received an email of some more discovery that my attorney sent me after I filed a motion to withdraw from him. The only reason why I filed this motion to withdraw from him is
Yes, there's due process. He got it. She went through it. She was actually quite patient about it, but there has to be a cutoff point. She hit it. God bless her. She made a decision.
because of the lack of discovery since day one. You know, Your Honor, every
Well
time I came
done.
here, it was, oh, Your Honor, the file's too big. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he's had to come in and buy a hard drive. Like, he made me as the client get a hard drive to go get it, and he still didn't give it to me in a hard drive. Your Honor, I have substantiating evidence to prove my facts, and I have submitted it. I have filed it in the clerk with the clerk. So if he's willing to say what he said to you in court, that he sent me discovery, I would love, Your Honor, if he could do a sworn affidavit statement stating what he said, so it could be put into.
He's an officer of the court, so he doesn't
Why don't you just ask the judge if she's horny?
have to do a sworn
Yes,
affidavit.
I understand, but I put the burden of proof. I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery until Saturday, 2 days before trial, 2 days before court date hearing. If you can look in the system, you'll see an affidavit statement signed by a notary that I signed under perjury, under sworn. I swore in, and I under perjury. I'm not trying to go to jail over lying. I'm telling the truth, Your Honor. He did not give me discovery until it was a Saturday. That Saturday before court, and it's big. It's a big file. And how could you miss that? Yes, he did send some before, but he smelled it, Your Honor. 1 month. 2 months out, 2 weeks after that, in 1 month after that, it's like he's been piecemealing this stuff to me, and then he says that, oh, the file's too big.
Oh, I want to see this go to trial, and I want to watch this guy go down in flames.
And this will make me make the decision to withdraw from counsel because he's not the best fit for me. Maybe he's a good attorney, but he's not probably the good fit for me. And this would make me want to represent myself because I wanted an attorney. But after I went through 6 months with dealing with him, and I was very patient, very patient. I didn't say a word. I didn't get upset with him. He wanted me to take a plea deal before I even got discovery. And that's what really made me not upset, but made me a little concerned because I'm like, you're representing me, but you want me to.
Yeah, I don't know the facts of this case, but my guess is they have like videotape of him committing the offense because this guy's dumb as it gets. And like, you don't need the discovery if you know that. You know? I don't know. I'm making that up, but that's my guess. My guess is that the scenario is something along those lines.
Take a plea deal without me having discovery, like, where's my due process rights? You know, that's a violation of my due process rights. I need to be able to defend myself. I cannot defend myself properly if I don't have all the evidence in front of me. That's all I've been trying to say.
You're acknowledging the discovery was signed, that discovery was received on April 14th. Miss.
Yeah, you got it, and you signed off on it. But you were correct. Finally, you did say something right, which is you cannot represent yourself properly. That much was correct.
Ferguson, could you have somebody from the state come down, please?
But it's not because of discovery.
And if you'll give him a reset form for June 16th.
Well, Your Honor, you're denying the fact that we have to go into jury without my due process for the record. I just want to know, Your Honor, for the record.
For the record, I mean, that's going to be your date to come back.
She's setting your case to come back. I'm giving him a fez. He gets at least an honorary fez. I'm not sure if he's full soft sit. But he's close enough.
Hello. Hi. So Mr. Lampkin is here.
Okay.
And he's saying that he has not seen any discovery.
That's not.
So
I already talked to Cornelius Marshall. I mean,
yes.
yeah, he invited me over to him.
Yes. So if you have the state's file, if you can let Mr. Lampkin see that. All right. Deputy Mejia, if you have him sit at the defense table.
So you know, I do have a work product, but it's not really work product. I'm going to set that up here.
All right.
Is this again?
You can look at it.
Okay, Your Honor, I say we're on the record.
Oh, we can be on the record.
Yes, I would love to be on the record. Anything we do in this proceedings, I would love to be on the record.
Oh, sure. We're back on the record in 2020.
I would love to be on the record.
4 CR 009936. State versus Carrie Lampkin. Yes.
Okay, Your Honor, you just mentioned when
hey baby, you want to go on the record with me?
And he said that I received it. He's saying that I received the discovery. Jason? I received this.
I didn't say you received discovery. I said, hey, this Marshall, your attorney, that you hired.
Yes, sir.
At that point, had received it and said on the record that he had shown it. That's what I said.
Okay, yes, sir. Just clarifying for clarification. Your Honor,
Here's the thing. What I want you to do is look at the discovery.
Yes, ma'am.
There it is.
okay.
Thank you. And he's coming back for jury trial on June 16th.
June 16th.
Yes. And Mr. Lampkin,
Yes, Your Honor.
just so you know, your attorney, when they have those portals with your discovery, every time you log into that portal to see something, it automatically
Okay.
documents that you have logged in.
That's what I'm saying.
All right.
That's why.
Yeah. And here's the thing.
Substantiated evidence. to
Here's
show
the
these
thing.
concepts.
What I'm telling you is you've received discovery from your attorney, but now there's the file right there with your discovery. So you're receiving it again. That's what I'm telling you.
Yes, Your Honor. And I have some concerns, but I'll address that once I finish dissecting this.
Mhm.
Mm-hmm. Yeah, she's done.
All right, Mr. Lampkin, you had something you wanted to say?
Yeah, that was bad.
Well, do you want me to find
Yes, Your Honor. Of course, we're on the record.
All right, so here's the thing. We're starting the jury trial. You're here for discovery. Take care of your discovery. Is there something outside of discovery?
Ma'am, it's regarding this discovery.
All right, so you'll need to be here tomorrow, and you need to be here tomorrow at 9 a.m. and we can discuss whatever discovery issues you're saying that you have. If it's something you're saying that should be there, is not there, you need to speak to the state.
Okay. Today still,
Yes,
and I have to do it already.
you're not allowed, you're to do it where the state is present because you legally, you're not an attorney. All right? Yes,
Now, Your Honor, I'm not able to get the copies of the.
you're not allowed to take copies.
My motion to get.
I'm telling you, you're not allowed to take copies. You're not allowed. Legally, you're not allowed. And your attorney would be able to tell you that. Legally, you're not allowed to have people's telephone numbers and addresses. So that's the law. That's not me saying it. That's not the state saying it. It's the law. All right?
I'll review it in the presence of the.
All right. Thank you. And if there's something you feel is not there that you think should be there, speak to the state. And I'm sure if they have it, they'll make sure that you're allowed to see it.
Yes.
Thank you.
Holy wow. That's messed up.
Oh, that will plead out if I had to guess. But if it doesn't, if that thing goes to trial, I will stream it. If that thing goes to trial, and it's at all possible, I will stream it because that will be an absolute disaster. That he's going to sit there and cry and emote about his feelings the whole time. Oh, that'll be fun stuff. All right. Big shout outs again to Law Nerds Unite, Lone Wolf, and Elkhart Court. Good stuff. Good stuff on a thrown together stream. I got thrown off course. I was trying to put together the stream, and then the Lau case popped up. Although there was no Lau. We just had, what's her name? Old Stinky Backyard Margaret. We just, that's all we had. We just had Stinky Backyard Margaret. If you don't know what I'm talking about, you really should. We had fun over there. We also took a victory lap on Laura Owens for no good reason whatsoever. That actually turned into a fun stream over there. All right. Thank y'all for coming out. I appreciate it. I will see you all soon.